Hi, I'm Kyle Persaud of the Persaud Law Office. In this video, I'm going to talk about how to get back child support dismissed. If you have a large child support arrearage, you may wonder, can I get it dismissed? And in some cases, the answer is yes. First thing to do is see if the other parent will agree to dismissing the arrearage. If the other parent will agree, you and the other parent can write an agreement, present it to the judge, and once the judge signs it, it'll be a binding court order and your arrearage will be dismissed. And one way you can work out an agreement is through mediation. You and your lawyer, if you have one, and the other parent and his lawyer, if he has one, can meet together with a mediator. And a mediator is not like a judge. He can't order anybody to do anything, but he can try to guide you toward a settlement. And if you have a settlement and you reach that to the mediator, you can also present it to a judge. And once the judge signs it, it'll be a binding court order and your arrearage will be dismissed. Now, if the other parent will not agree to dismissing the arrearage, you'll have to go to court. And what you would do is you would file a motion in court and ask the judge to dismiss the arrearage. You've got to understand, though, dismissing a child support arrearage is the exception, not the norm. Therefore, to get the judge to dismiss the arrearage, you'll have to present a good faith reason as to why he should dismiss the arrearage. The judge is not likely to dismiss an arrearage just because you ask him to. You'll have to show why the current arrearage is unjust. And there are two possible arguments you could make to show that the arrearage is unjust. One, you can argue that the original order was unlawfully entered. Or two, you can argue that you've already paid all the arrearage and don't have to pay anymore. Now, to argue that a child support order was unlawfully entered, first look at the circumstances under which the court entered the order. Did you appear at the original child support order hearing? Did you receive notice of the original hearing and not go? At the hearing, did you raise objections to the arrearage at the hearing? And also, if you did raise objections, the judge overruled your objections, did you appeal them? And if the answer to any of those questions is yes, you probably can't get the arrearage dismissed because there's a law called res judicata. Res judicata is a Latin phrase that says you can't relitigate issues you've already litigated or could have litigated. Now, you may all be able to argue the child support order was unlawfully entered if you didn't receive notice of the hearing when the court entered the order. The U.S. Supreme Court has held that it's unconstitutional to take any money from you if you didn't give notice and opportunity to be heard. So if you've got something in the mail saying you have an arrearage and you don't remember ever getting notice of the hearing when the court ordered the original child support, then you should definitely file a motion to dismiss the arrearage. Now, if the original order was lawfully entered, you can still argue that you've paid all child support you've ordered to pay. And you can introduce any evidence that is, quote, relevant as long as there is no law that specifically excludes the evidence. And under Oklahoma law, relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the termination of the action more probable or less probable than it would be without the evidence. And in the description box below, I've put a link to Oklahoma law and evidence. And so if you have any evidence that makes it more likely that you've paid child support, you can introduce that evidence unless there is another law that specifically excludes that evidence. And if you have receipts showing you have paid, introduce those receipts. Now, you also need to remember that at your hearing, if the other parent or the state and federal government argues that you didn't pay child support, then they have the burden of proof. They have the burden of proving you didn't pay. You don't have the burden of proving you did pay. Now, if the judge won't dismiss the arrearage, then you can do two things. One, you can work out a payment plan, and judges will generally be flexible in letting you work out a payment plan as long as you do pay. And also, you can appeal. And you can appeal to the Oklahoma Supreme Court in the description box below. I put a link to the appeals process. But keep in mind, your chances of winning may be slim. Under Oklahoma law, the Supreme Court is generally not supposed to overrule a lower court unless the lower court, quote, abused its discretion. Abuse of discretion usually means that the lower court made a clear error was against the weight of the evidence. And you have a high hurdle to overcome if you want to prove the lower court abused discretion. Now, if you do want to get child support arrearage dismissed or reduced, you probably need to consult a lawyer. The process is very complicated. If you and the other parent have reached an agreement, you probably need a lawyer to help you write out that agreement and submit it to the judge. Or if you want to file a motion to dismiss the arrearage, or if you want to file an appeal, then that's a really complicated process, and you'll definitely need a lawyer there. And at the Persaud Law Office, we've handled many child support cases, and we have represented clients in cases where an arrearage has been dismissed or greatly reduced. So if you want to see about getting a child support arrearage reduced, you can contact us today. I've placed a link in the description box below. Also, it might be good to contact a lawyer to see if you really have a case at all. As I said, dismissing a child support arrearage is the exception, not the norm. And so you may want to consult a lawyer just to see if you really have a chance of getting her in arrears dismissed at all, or if it's just a fool's errand. But in any event, you may want to consult a lawyer just for guidance in the complex maze. At the Persaud Law Office, we've handled a number of child support cases, and we have had cases where a judge has dismissed or greatly reduced a child support arrearage. And so if you would like help contesting your child support arrearage, feel free to contact us today. I've placed a link to our contact form in the description box below. Thank you very much.